two of the most broad federal criminal statutes are the mail fraud statute and the wire fraud statute. And they're that way on purpose. Basically, they are designed to take any type of fraudulent activity and to convert it into a crime if there's been use of the U.S. mails or if there's been use of the wires. For example, internet, fax, telephone, or any other wire communication. Now, it's almost impossible in today's day and age to engage in any kind of activity without using the mails or the wires. Now, oftentimes there's very little difference between a civil business dispute and what is a civil matter and civil fraud and what is criminal fraud. And people often ask me the difference between the two. And I'm actually very hard pressed to tell them, because any type of fraudulent activity in which the mails are used or the wires are used can be indicted as a mail fraud case or a wire fraud case. Of course, the standard of proof is much higher. That is, proof beyond a reasonable doubt. But as a result of the breadth of these two statutes, they have become the prosecutor's darlings. And in almost every federal criminal case outside of drug cases, there is a wire fraud count or a mail fraud count. Now, as in any other criminal case, the government is going to have to prove beyond a reasonable doubt that somebody knowingly and intentionally engaged in the fraudulent conduct. And usually that's where the defense lies in these cases. Not that the mails weren't used, not that the wires weren't used, not even that the person didn't do many of the things the government accuses of them doing. However, they did not do that with the specific intent to defraud. That is the key element of these offenses, that there was a specific intent to defraud. And that generally is where these cases are won or where they're lost. And obviously, it's very important to be able to present evidence showing that somebody is not the type of person that would have intentionally engaged in fraud. To present character evidence, for example. And if the person is capable of testifying, to have them testify as to the legitimate reasons they were engaging in this conduct and why they had no specific intent to defraud. If you are under investigation for mail fraud or wire fraud, it's important that you hire an attorney that's well versed in handling these types of criminal cases. I've been handling them as a federal prosecutor since 1978 to 1980, and as a defense attorney from 1980 to present.